The creative industry in South Africa is up in arms over the possible consideration and adoption of Copyright Amendment Bill and the Performers Protection Amendment Bill. Early this month, the Parliamentary Portfolio Committee on Trade, Industry and Competition announced the adoption of the bills. Now, for years, the bills have been a contentious issue for many in the creative industry. The bills are scheduled for consideration and adoption by the National Assembly on Thursday. To discuss this further, we are joined by the chairperson of the Copyright Coalition of South Africa, Chola Makhamate. Chola, thank you. Thanks for joining us. We did, in fact, invite the chairperson of the Portfolio Committee on Trade, Industry and Competition, Judy Hermans, but she was unavailable to be with us in this interview. So, Chola, thank you for your time.
Thank you, Leanne, and good morning to you and your viewers.
So, for people that are unfamiliar what's about to happen and they're unhappy with the bills, let's understand why and what are the negative effects are when you compare them to the current status quo.
I think from the outset, I must articulate that we do support the amendment of these bills. These are very old pieces of legislation, and they do need to be amended so that they're brought in line with what's happening in the world currently, how works are consumed, and how copyright operates. I think our challenge with regards to how the bills have been worded in their final versions is that they go against the intention of the bills originally, which was to better the creative industries and to have more protection for creatives and so on and so forth. But what the final product, what we have now, what is going to go before Parliament on Thursday is a version of bills that reflects a lack of understanding of how the creative industries operate. So, for instance, what the trigger point for actually the amendment of these bills was what was happening with creatives, in particular in the music industry. And what the legislators have now gone and done is that they've taken those concerns, tried to deal with them in legislation, poorly at that I must add, and then taken how they've dealt with music as a sector within the creative industries and applied those rules to other sectors within the creative industries. And if they had a proper understanding of how the creative industries operate, music operates differently to the audiovisual sector, which is film and television. It operates differently to the book publishing sector. It operates differently to the animation sector. So you have a bill that currently has provisions that are a one-size-fits-all in the industry, which isn't one-size-fits-all.
No, it certainly isn't. I mean, just by you saying that, I mean, one can completely understand. These industries are totally different with totally things coming out of them, and you try and put this bill to work for everybody. I don't think that would work. Perhaps you can give us an idea, a practical example of if this has to be passed in its now current amended form. What are the consequences? What are those implications that would happen?
So aside from this one-size-fits-all approach, what they've done is that they've taken a law that has certainty around it. The rules of the game in terms of how you are protected when you, for instance, write a song, vis-a-vis what needs to happen if somebody wants to use that song and how you're paid, and the fact that they have to ask permission. We have certainty currently. What they've done, which is very dangerous, is they've introduced a concept of fair use and broad exceptions, which would create uncertainty. So there wouldn't be clarity for anyone in terms of when they would be protected when their works are used and when they would need to be paid for the use of their works. And they would have to take people to court in instances where somebody was claiming that there was an infringement of their copyright. So you are introducing uncertainty into our law. You are going to increase litigation, and you know that the average creative in this country cannot afford litigation.
Yeah.
And you are also creating a situation, to be quite frank, where because of that uncertainty, you will make investors scared to invest in this country, particularly in sectors like the audiovisual sector, where you have big production companies constantly looking at different jurisdictions where they can come and make investments, have productions here, create employment, etc., etc. But because you have this uncertainty in the law, you're going to make investors skittish, and they'll disinvest and really go and invest in other jurisdictions where there is certainty about how things operate.
Others, however, would argue that these are progressive bills that will afford South Africans the rights similar to those enjoyed by people in many other countries around the world, and that the bill is aimed at valuing artists, but they also ensure that marginalized groups have fair access to creative work and works of knowledge such as textbooks. What would be a response to that?
It's very simple. It's important to have access. That's an important issue, and it must be addressed. But must it be addressed at the expense of, for instance, the writers of those textbooks? They have to get paid. They put their effort, their creativity into writing those textbooks. They have to earn a living from it. Imagine if you came to work and someone said, oh, hang on, we need access to this information or whatever it is that we need for marginalized groups. We're not paying you your salary, really. Just do it for the better good. So we must be able to address these issues, but not at the expense of the creators who need to be remunerated, and not at the expense of the industry surrounding those sectors that actually invest in this country and provide a living for actually not just the writers, but various people and organizations in those value chains.
Yeah, and it is important to bring protection for artists and performers in South Africa, because, you know, one of the issues that still for me just it always sticks in my mind was when Charlene Surtee Richards passed away, and this lady who formed a major part, and I'm only bringing one example because I can't help but bring her face to my head when this does happen, that towards the end of her life she could not afford medical. She couldn't afford medical treatment. She had absolutely nothing to show for the sterling work that she did for South Africa and the arts here in South Africa. And we need to protect our artists. And I know it's just one example of so many different industries, but that is a great example.
It is a great example, and it's unfortunate that we have this, and it continues to happen. And one of the tragedies of this legislative process, you had mentioned in your intro that we're discussing the Copyright Amendment Bill and the Performance Protection Amendment Bill. Sorry, these two bills have been linked because they deal with, on the one hand, creators and the protection of the creators, on the other hand, performers and the protection of performers. And because they have been linked, it has caused a great divide between creators of works and performers of works, which Charlene was. She was a performer of the works. And unfortunately, we do acknowledge that there is a huge problem. There's still problems that continue to exist. But the way the bills have been drafted will actually not address those issues. It will exacerbate those issues, because you need to think of these two bills as a mother and the child. CAB as the mother and the Performance Protection Amendment Bill as the child. If you kill CAB and are unable to protect creators, ultimately performers will have nothing to perform. And that effectively will kill the creative industries, because without the works to perform, you can't earn a living. And that situation that you've explained now in terms of how the actors are being treated and how they're unable to show to their children, to their grandchildren, what they've done with their lives, or be able to give something to them, that will continue to happen, because you have a country where you are unable to protect, firstly, the creators of the works, and ultimately the performers of those works.
All right, we've got to leave it there, but this is so important. I know that this goes to the National Assembly, then the bills go to the President's desk. It takes some time for that to happen, and let's just hope that whatever does happen, the fairness is given to those that are behind these ideas, and their talent is recognized for the rest of their lives. Chola, thank you for talking to us. Chola Makhamate is the chairperson of the Copyright Coalition of South Africa, which speaks about remitted bills which are up for reconsideration by the National Assembly.